Presidential Election Petition Court (PEPC) sitting in Abuja on Monday rejected requests to allow its day-to-day proceedings on petitions seeking to nullify the outcome of the 2023 presidential election to be televised. The Justice Aruna Samani, led by five-member panel, dismissed as lacking in merit the application which was brought before it by the two major candidates that are challenging the outcome of the presidential election that held on February 25th. The court held that no regulatory framework or policy direction permitted it to grant such application. It held that allowing cameras in the courtroom is a major judicial policy that must be supported by the law. The court can only be guided and act in accordance with the practice, directions, and procedures approved by the President of the Court of Appeal. We cannot permit a situation that may lead to dramatization of our proceedings, Justice Samani held. Besides, the court held that the request was not part of any relief in the petitions before it, saying it was merely hinged on sentimental claim that it would benefit the electorate. It maintained that the petitioners failed to establish how televising the proceedings would advance their case, adding that such live broadcasts would not have any utilitarian value to add to the determination of the petitions, whereas it was a former vice president and candidate of the People's Democratic Party (PDP), Alhaji Atiku Abubakar, who came second in the election, that initially made the request for a live coverage. Subsequently, candidate of the Labour Party, Mr. Peter Obi, threw his weight behind the demand for live broadcast of proceedings of the courts on the petitions. They drew through their lead lawyers, Chief Chris Uche, SAN, and Dr. Levi Uzoku, SAN, maintained that petitions they lodged to query the declaration of the candidate of the ruling All Progressives Congress (APC) Tinubu as winner of the election was a matter of monumental national concern and public interest. They argued that the case involved the interests of citizens and electorate in the 36 states of the Federation and the Federal Capital Territory, Abuja, who is said voted and participated in the presidential poll. Atiku and the PDP insisted that their case against Tinubu, being a unique electoral dispute with a peculiar constitutional dimension, they said it was a matter of public interest in which millions of Nigerian citizens and voters are stakeholders with the constitutional right to be part of the proceedings. They specifically applied for an order directing the court registry and the parties on modalities for admission of media practitioners and their equipment into the courtroom. With the huge and tremendous technological advances and developments in Nigeria and beyond, including the current trend by this honorable court towards embracing electronic procedures, virtual hearing and electronic filing, a departure from the rules to allow a regulated televising of the proceedings in this matter is in consonance with the maxim that justice must not only be done, must be seen to be done. Televising court proceedings is not alien to this honorable court and will enhance public confidence, the petitioners added. However, in separate processes they filed before the court, both tribunal and the APC urged the court to dismiss the application, which they describe as an abuse of the legal process. Tinubu, in a counter affidavit he filed alongside the Vice President-elect Kashim Shettima, accused Atiku of deliberately attempting to expose the judiciary to public opprobrium. According to them, the court is not a rostrum or a soap box. It is not also a stadium or theater. It is not an arena for public entertainment. The respondents maintained that Atiku's request had no bearing with the petition, insisting that it was only aimed at dissipating the judicial time of the court. They stressed that Atiku failed to realize that the virtual court system that was adopted during the COVID-19 pandemic was backed by a practice direction that was administratively issued by the President of the Court of Appeal. Another angle to this very curious application, in the invitation, it insists to the court to make an order that it cannot supervise. The position of the law remains, and we do submit that the court, like nature, does not make an order in vain or an order which is incapable of enforcement. The respondents added. Besides, they argued that the application was at best academic, very odious, very unnecessary, very time-wasting, most unusual, and most unexpected, particularly from a set of petitioners who should be praying for the expeditious trial of their petition. So, in a nutshell, they say they don't want it to be televised. And a lot of people are like, wow, wow, why should it be so? Why should it be so? We don't want that. In the recent, is it going to add or is it going to subtract to whatever? At least they will have their witnesses there. Uh, I don't think there's anything they're going to go and do in the corner that says some of their witnesses or their witnesses will not be allowed in there. It is not supposed to be a bad thing, but you know the way things are being done. When it comes to this kind of a thing, they will now be defending, they will be talking about law, all of that. But if it's to them, they will still know how to come in a corny way. So guys, let's hear your opinion and have your take on this.